So, ladies and gentlemen, good morning or afternoon, depending where you are located. I'm Dr. Costantino Grasso, an associate professor of business and law at Manchester Law School, and in my capacity as the editor-in-chief of the Corporate Crime Observatory, it is my honor to introduce and welcome you to our event, From Leaks to Justice, Challenges and Opportunities for the Judiciary in the Age of Disclosure. First and foremost, I would like to thank my fellow scientific coordinators and co-organizers, Professor Diane Ring of Boston College Law School and Dr. Donato Vozza of Roehampton Law School. I would also like to extend my sincere gratitude to our outstanding partners that have supported the organization of this International Roundtable: the Italian Superior School of the Judiciary, Naples section, the Moldovan National Institute of Justice, the Government Accountability Project, the Association of Corporate Investigators, and Whistleblower Partners LLP. Today's event is not only distinguished by the scientific relevance of the topics covered, but also by the fact that it will serve as a high-level training opportunity for all the attending authorities. In this regard, we are extremely honored that in addition to the Italian and Moldovan members of the judiciary, judges and prosecutors from over 20 European Union countries who are participating in an exchange program within the European Judicial Training Network are attending the event in a room specifically arranged at the Court of Naples, and that several officers of the Guardia di Finanza have gathered together at the Italian Economic and Financial Police School in order to attend and join the discussion. I would also like to extend our sincere appreciation to all the members of the audience that are taking the time to join us online today. In recent years, significant disclosures by whistleblowers and leakers, complemented by investigative journalists, have played a crucial role in exposing otherwise hidden forms of criminal activities. Notable examples include the Panama Papers, the Paradise Papers, which unveiled extensive networks of tax evasion and money laundering involving high-profile individuals and corporations globally. These disclosures have played a fundamental role in uncovering the hidden mechanism through which illicit funds are moved and concealed. Investigative journalists have built upon these disclosures, analyzing the leaked documents and conducting in-depth investigations to put together the complex web of financial malpractice. Their work has brought to light how sophisticated schemes are orchestrated to avoid detection by regulatory bodies, often involving a combination of shell companies, offshore accounts, and legal loopholes. This effort has not only exposed criminal activities such as tax evasion, fraud, and corruption, but also highlighted systemic issues within the global financial system that facilitate such crimes, as well as concerning situations of collusion between authorities and private interests, as we've seen in relation to the LuxLeaks scandal. These revelations have led significant legal and regulatory responses. The public awareness generated by these high-profile cases has pressured governments and international organizations to establish new policies aimed at increasing transparency and accountability and countering these criminal activities. Moreover, authorities worldwide launch investigations, resulting in several prosecutions and fines. Despite the significant role of disclosures by whistleblowers and leakers and the subsequent investigative work by journalists, there remains a lack of consistent and stable coordination between these efforts and the formal investigative processes. This gap is multifaceted, involving legal, institutional, cultural, and practical challenges. It is possible to identify a certain level of disconnection between the objectives of the methods of investigative journalists and those of law enforcement agencies. Journalists prioritize uncovering and publishing information in the public interest, sometimes without the stringent evidentiary standards required by legal authorities. Conversely, law enforcement agencies may be reluctant to rely on information obtained through leaks due to concerns about legality and admissibility in court. This mismatch can lead to valuable information being underutilized or ignored in formal investigations. Today, we will explore some of these dynamics with the purpose of fostering a constructive discussion aimed at enhancing the synergy between investigative journalists and legal practitioners. In order to achieve this objective, we will hear comments and opinions from a terrific group of panelists, including investigative journalists, members of the authorities, distinguished academics, and representatives from civil society. Thank you so much to all these experts who have decided to join our discussion today and share their valuable insights. We are deeply grateful to have you with us. It is now time to go ahead with our busy schedule. I encourage all attendees of these events to use Zoom question and answer interface if you wish to ask questions, express opinions, or share cases and stories you find interesting. We are eager to learn from your experience too. I'm now honored to introduce the co-organizing and moderator for this roundtable, Professor Diane Ring. She serves as a professor of law in the Dr. Thomas Carney Distinguished Scholar of Boston College Law School. Professor Ring is an esteemed expert in international and corporate taxation. Her academic work addresses critical issues such as tax ethics, tax leaks, corruption, international tax relations. She's also the co-author of the paper entitled The Leak-Driven Law, which was published in the UCLA Law Review and expressly focused on analyzing the impact of leaks in the area of taxation. Dear Diane, the floor is yours.
Thank you very much. So as Costa mentioned, we have some wonderful partners sponsoring and sort of working with us today for our event. And I wanted to, in turn, invite representatives from each just to give some welcome remarks. So first, I would like to give the floor to Major General Francesco Matana, Commander of the Economic Financial Police School of La Guardia di Finanza.
Thank you. Good afternoon. Illustrious Chancellor Barbara Modesta Grasso, eminent speakers, distinguished prosecutors, representative of Italian and foreign authorities, welcome guests. As the commander of the Economic and Financial Police School of the Guardia di Finanza, I would like to express my thanks for the opportunity given to the Institute to take part in today's roundtable discussion. The Economic and Financial Police School is the Guardia di Finanza Training Center of Excellence for the updating and advanced training courses for the personnel of the corps, other public administration, law enforcement, agency, and international organization, as well as a center for the development of study and scientific research activities in economic and financial matters. Every year, the school provides updating and qualification courses to thousands of its officers, both on site and with the most advanced learning technologies. The school international projection is also important as a center of culture and research by the world-leading organization. Over the years, the Institute has been designated as OECD International Academy for Tax Crime Investigation, as a Partnership Academy of the European Border and Coast Guard Agency, Frontex, as a framework partner of CIPOL, the European Police Training Agency, and since last year, as Academy for the European Public Prosecutor's Office. With specific reference to the topic of the roundtable, it must be considered that the use of information or list of names acquired outside official channels of international cooperation or in the context of judicial administrative activities is a controversial topic. It has been the subject of progressive jurisprudential evolution, which also involved activities developed by the courts. And between these, I mention briefly the case of the Panama Papers acquired in the framework of journalistic investigation. In short, we can state that the jurisprudence has placed emphasis on usability of the information, also noting the need to verify the reliability of the data and the validity of the tax presumption. And in this case, I point out also that the recent reform of the Italian Statute of Taxpayers' Rights has expressly regulated this issue. Finally, on this occasion, I would also like to mention the beginning of the collaboration agreement signed in 2019 and recently renewed between the Superior School of Judiciary and the General Headquarters of Guardia di Finanza. In the context of this collaboration, the Economic and Financial Police School hosts the annual conference organized with the Superior School of Judiciary. For 2024, the years in which the Guardia di Finanza celebrates its 250th anniversary of its foundation, the conference with the school will probably be organized next December. As a commander of the school, the Institute of Higher Learning of Guardia di Finanza, I think that an important action to fight crime also depends on the training quality of our officers. Constant updating, therefore, is a key factor in which to invest appropriate resources to ensure a stronghold of legality always adequate. In this context, I reaffirm my gratitude for the opportunity to be able to take advantage of this important training meeting. The discussion will be followed remotely by the attendees of the 51st Senior Course of Economic Financial Police, the most selective and demanding qualification course. Once more, I thank all the authorities and the guests for their attention, and I wish everyone a fruitful work. Thank you.
Thank you very much. I'd now like to turn to Barbara Modesta Grasso, Coordinator of the International and European Criminal Law Division at the Naples branch of the Italian School of the Judiciary, to offer a welcome. Barbara, you're on mute.
Yes, I'm sorry, I was mute. Okay, can you hear me? Thanks very much for the floor, Diane. Distinguished and honorable panelists and participants, the training section of the Italian Superior School of the Judiciary in Naples is honored to participate in this important event organized by the Corporate Crime Observatory in cooperation with many other relevant institutional partners. I'm also delighted to let you know that this week, as part of the exchange program for judicial authorities of 2024, the Court of Appeal of Naples is hosting 23 members of the judiciary from other European Union countries. They are with us today to attend this international roundtable. It is a great pleasure to share our participation with colleagues from Moldova and the officers from Guardia di Finanza. Collaboration and exchange of knowledge among authorities foster our common understanding of issues of transnational relevance focused on whistleblowing and leaks. In a time of significant disclosures, especially in the area of financial crime, prosecutor and investigator must update, as the general already said, their strategies to uncover complex and illegal activities. At the same time, the judiciary must carefully examine these disclosures and the related documents to ensure investigation respect the rights of the citizen and the rule of the law. Despite transposing the leaks and journalistic pieces of information into judicial action is both important, I think, and complex, this phenomenon has not yet received adequate reflection. As a result, the training of members of the judiciary on these complex issues is essential nowadays, especially using a perspective that goes beyond national borders. In this regard, I would like to suggest that it may be useful for the organizers to prepare, based on their research outcomes, a training document that can be circulated as a tool to promote the continuous training of representatives of authorities. We believe that our involvement in this formative event represents a valuable experience. We look forward to participating from Naples in this fascinating discussion. Thank you very much for having us.
Thank you, Barbara. I would now like to turn to Olga Marandici, Head of the International Relations Section, National Institute of Justice, Republic of Moldova, for her welcome. Thank you.
Thank you so much. Distinguished audience and experts, it is a great honor and enthusiasm that I welcome you on behalf of the National Institute of Justice today to this pivotal discussion on From Leaks to Justice, Challenges and Opportunities from the Judiciary in the Age of Disclosure. This event brings a group of experts, practitioners, and leaders to delve into the critical issues surrounding information leaks and their impact on the judiciary and pursuit of justice. The significant discussions cannot be overstated in an area where the information can be disseminated globally within seconds. Leaks, wherever they originate from, whistleblower, cyber attacks, or inadvertent disclosure, have the potential to influence public opinion, the fairness of the judicial processes, and the impact of the perception of justice. Today, our judges, prosecutors, trainees, and trainers can gain insights into the last challenges and innovative solutions, enhancing their professional capabilities. This event offers a unique platform for networking within international peers and experts. By fostering this connection, the NAJ can enhance its collaborative efforts, share knowledge, and develop joint initiatives that strengthen the judiciary. And in conclusions, I want to say that today's discussion is not a dialogue, but a vital step towards fortifying our judiciary on the age of disclosure. Thank you very much for this opportunity and enriching experience.
Thank you very much, Olga. I'd now like to turn to Tom Devine, Project's Legal Director at the Government Accountability Project, for his welcome.
Thank you very much for honoring us with this invitation. I think the best contribution I could make at this stage is probably defining who leakers are. People who engage in leaks are a subset of the whole legal revolution of protection for whistleblowers, protection and free speech rights for whistleblowers, if they're engaging in protected speech. If they're not engaging in protected speech, leakers could be secret gossipers. But if they're engaging in activities, if they're disclosing misconduct that's covered by national laws, in particular whistleblower laws, they are simply the confidential channel to get the truth into the right hands. And it's very important that in many instances, why whistleblowers need to be leakers, at least at the beginning of their journey. One is it prevents retaliation. They can't be silenced or purged if they're not identified. The second reason, though, is it sustains the flow of evidence. As long as a whistleblower is anonymous, they can keep learning of ongoing developments that may be significant or decisive evidence of crimes. And finally, they can act as watchdogs for corrective action commitments. Almost every institution that's exposed for some sort of indefensible misconduct, like our children, says, "I'll be good from now on. I won't do it again." And often those commitments aren't credible. Well, you need somebody there to maintain and have oversight of the follow-through for exposure of a breakdown in public trust or abuse of authority. So in the work of the Government Accountability Project, we're a whistleblower support organization. We advise people to remain anonymous as long as possible because that will maximize their impact. Sooner or later, they may need to go public in order to bear witness in the right forum. But until that imperative, sustaining the flow of information, preventing retaliation, and keeping on top of ongoing developments are the very, very worthy reasons why we need leakers.
Thank you very much. And now I'd like to turn to Ashu Sharma, Executive Head of Advisory of the Association of Corporate Investigators.
Thank you very much, Diane, and hello to everyone. Thank you very much for the invitation. The Association of Corporate Investigators represents corporate investigators from around the world. What do they cover? What do they investigate? Financial crime, regulatory matters, including environmental and safety and health, and then, of course, psychosocial matters as well. Our members are corporate investigators in-house. They are lawyers, they are accountants, they are anyone that will come in to investigate a concern that is raised in a speak-up line, in a whistleblowing line, and their job is to really make sure that the matter is investigated fully. To help them do that, the ACI mentors, educates, and supports those members to do the best job possible. We were one of the co-authors of the ISO 37008, Internal Investigations of Organizations, which is the very first international standard to come out for internal investigations. And our goal really is to look at those matters that are leaked and that come out and make sure that those who are brave enough to whistleblow are offered the full protections that are required by an independent in-house corporate function to ensure that the matter is effectively managed. So this session today is of great importance to the ACI. We very much want to contribute it, especially when the Panama Papers and Paradise Papers and all these leaks pretty much would be investigated by our members when they hit the papers. Thank you.
Thank you very much. And thank you to all of our partners in this. So